Morning, everybody. We'll go on the record here in Bingham County. This is case number CR 0621-6435, State of Idaho versus Craig Rowland. Any reason for opening arguments, or can we just move right into evidence?
We can go straight into evidence, Your Honor.
Mr. Nye, call your first witness.
Were you involved in an incident involving Mr. Rowland on November 9th, 2021?
Yes.
So I'd like to discuss that incident with you a little bit. Where did that occur?
In the road in front of his house.
And about what time did the incident occur on November 9th, 2021?
Just before 8 p.m.
Why were you at the Rowland home, or outside the Rowland home on that particular day?
I was chaperoning a young women group delivering a thankful turkey.
What is a thankful turkey?
They traced their hands, cut out with paper, glued them into a shape of a turkey, and wrote what they were thankful for certain people on it.
And what was your role in that particular project?
I was the young women's leader in charge of it.
And when you talk about the young women's group, what is that?
A church group of girls ages 11 to 18.
And when delivering those turkeys, what procedure or what did the girls do to deliver those?
They wanted it to be anonymous, so I would drive to the house. They would decide who would get out, a couple of the girls. They would get out, go tape it to the door, knock or ring the doorbell, and run back to the car, and then we would leave.
How many girls were with you at that time?
7.
And what were the ages of the girls who were with you?
They were in between 11 and 15.
What happened when you first arrived out on the street outside the Rowland home?
A couple of the girls got out. They ran to the door, and then saw that he was outside and ran back.
Object or testifying as to what some other person may have seen without foundation as the basis for her knowledge.
Ms. Keene, there's been an objection as to lack of foundation. Do you wish to respond?
I will clarify that, Your Honor, so I'll ask a question.
Go ahead.
Thank you. So you indicated that a couple of girls got out and of the vehicle.
Yes.
Did they return to the vehicle?
Yes.
Had they left the turkey, or did they still have it with them?
No, they hadn't made it all the way to the door.
I'm going to object, Your Honor, again, lack of foundation. She said in the car she can't testify what somebody else did or didn't do.
I'll follow up, Your Honor.
Go ahead.
Did you actually see the girls when they ran up toward the door?
Yes.
And were you able to actually see whether the girls got all the way to the door?
No.
And so you just saw that they ran toward the door and then they returned?
Yes.
Okay. And did they have the turkey still with them when they returned?
Yes.
Did you and the girls decide to return to the home later to deliver the turkey?
Yes.
And about how long was it between the first time when the girls ran and returned and the second when you came back to the house?
About 10 minutes.
And so you said that you and the girls returned a second time about 10 minutes later. Did the girls get out of the car that second time?
Yes.
And did they have the turkey with them then?
Yes.
Do you recall how many girls got out?
No.
And did you see any of their actions after they left the car?
No.
Did you see them return to the car?
Yes.
And did all of the girls return to the car?
Yes.
Did you see whether they had gone toward the Rowland house?
Yes.
And did they?
Yes.
When the girls returned to the car, where was the car at that time?
Parked just right before my parents' house, which is next door to the Rowland house.
And is their house directly next door?
Yes.
When the girls returned, were there any girls that were seated in your front passenger seat?
Yes.
How many girls?
2.
And were there any girls seated in the back?
Yes.
How many girls were seated in the back?
5.
And does that vehicle just have the front and back seat, or is there a third row?
Yes. Just the front and back.
And what did you do after the girls returned to the vehicle?
I was driving down to exit the cul-de-sac.
And when you're exiting the cul-de-sac, would you proceed past the defendant's home, or
Yes,
once you started driving, did you observe Craig Rowland?
yes.
Where were you on the street at the time that you observed him?
Just right before I got to their house.
Oh, when you say their house, you mean the Rowland home?
Yes.
And did you notice anything about Mr. Rowland when you first saw him?
He was walking fast towards the road.
And what did you do when you saw him walking fast toward the road?
I slowed down because he was waving me down to stop.
And was he waving you with one hand or two hands?
One hand.
And did you notice whether there was anything in his other hand?
Yes, there was a gun.
And so you said you slowed down. Did you ultimately stop your vehicle?
Yes,
And why did you do that?
because he was waving me down to stop.
And you indicated that there was a gun in the other hand. How was that positioned at that time?
Just down at his side.
And did Mr. Rowland, after you stopped your vehicle, did he continue approaching the vehicle?
Yes,
And when he approached the vehicle, where was the gun at that time?
pointed at the car.
And when you say at the car, was it pointed at a specific area of the car?
Yes,
What area was that?
pointed at me and then to the passenger's seat and then back at me.
And at the time that the firearm was pointed at the passenger seat, you said that before you said there were two girls in the passenger seat. Was that still the case when the gun
Yes.
was pointed there?
Yes,
And after the defendant pointed the gun at the passenger seat, where did the gun move?
back to me.
And at that time, with the vehicle stopped, what did you do?
I opened the door because the window doesn't work. So I opened the door so I could tell him that we were there just dropping off the turkey.
When you opened the door, did you exit the vehicle?
No,
Did you begin to exit the vehicle?
no, because I had just put my foot on the brake. I hadn't put it into park.
After you opened the door, did the defendant say anything to you?
Yes,
What did he say?
he said, "Get out of the effing car."
And when you say effing, is that what the defendant used?
No,
Did he actually say the word?
yeah, yes.
And after the defendant told you to get out of the car, what did you do?
I turned back to the middle to put my car in park.
And so the gear shift is in the middle of the vehicle?
Yes,
And what happened next?
I put the car in park and sat up, and he yanked my hair down and I said, "Get out of the effing car."
And when you say he, are you referring to Craig Rowland?
Yes,
Before the defendant grabbed your hair and said to get out of the car, had you attempted to exit the vehicle?
not yet.
Did you exit the vehicle after the defendant grabbed your hair?
Yes,
Why did you do that?
because he told me to.
After you had exited the vehicle, where were you and the defendant standing?
Just right next to the driver door.
And how was Mr. Rowland positioned in relation to you?
Just in front of me.
So you were facing each other?
Yes,
And where was the gun at that time?
pointed at my head, about a couple inches from my head.
And did the defendant say anything to you at that time?
Yes, he said, "I'll effing shoot you."
And did he ask you any other questions?
No,
At any time, did he identify himself as law enforcement?
no,
And did Mr. Rowland ever tell you why he stopped you or why he pulled you out of the car?
No.
And you indicated he asked who you were. Did Mr. Rowland ever give you any indication that he recognized you?
No.
And what did you feel when he didn't recognize you and had a gun to your head?
I was worried when I noticed that it appeared he didn't know who I was.
Did he say anything else to you during that time?
He said, "Don't ever do that to me again. Get the F out of here."
And at that time, were you able to leave?
I got in the car, and then he tried to shut the door, but I wasn't all the way in yet.
So was the door able to shut at that time?
No.
And then what happened?
I tried to finish getting in, and he shut the door again, and my foot was almost in, so it didn't shut again. So I just started driving, and then shut the door.
And after this incident happened, did you have any contact with Lisa Rowland or Craig Rowland?
Yes,
With both or just one?
both.
And did you, at one point in that evening, apologize to Lisa Rowland?
Yes.
Why did you do that?
I felt bad there was a misunderstanding.
And you were familiar previously with Mr. Rowland's home. Were you aware of anything he had that made you feel more comfortable going to his home at night?
Yes.
What was that?
I knew they had a Ring doorbell.
And you indicated previously that Mrs. Rowland had been involved with the Young Women's Group.
Yes.
And so did she know you and the girls who were with you that day? Did Mr. Rowland also know you and the girls who were with you that day?
I don't know if he knows the girls. He knows me.
Thank you. I have no other questions this time.
Thank you. Cross-examination, Mr. Olson.
Thank you, Your Honor. Ms. Cox, you said you've known the Rowlands for 20-some years.
Yes.
And you grew up next door, right?
Yes.
You're familiar with, I guess, their protocols for visitors, aren't you?
I'm
You're not aware that when the lights are on, you're welcome. When the lights are off, you're not?
not. No.
You've never been aware of that?
No.
Have you ever gone over to their house when the lights are off?
I usually go over in the day.
Okay. So you've never attempted to go over to their home when the lights are off?
No.
You're aware that Mr. Rowland is the sheriff, right?
Yes.
And he has been for a while, right?
Yes.
Okay. And I assume you're also aware of being the sheriff, that's kind of a higher risk occupation, right?
Yes.
You're aware that people threaten him, is
Objection.
that correct?
Lack of foundation.
Mr. Olson.
Okay. Are you aware of any threats that Mr. Rowland has had based upon his occupation?
No.
And so you said he was waving you down, you stopped, and you didn't roll down your window, you opened your door.
The window doesn't work, so I open the door.
So you're sitting in the driver's seat, you open the door, where is he at when you open the door?
By the front headlight, driver's side.
So he's in the front of the car,
Yes.
okay?
To the side, not directly in front.
Not directly in front, but, okay, so if the car's here, he's in front of the car though? I mean, he's not
No.
past, is he past the headlight or is he by the headlight?
Just right next to the headlight.
So he's right next to the headlight. That's when you open your door.
Just barely, so I could let him know why we were there.
Okay, that's fine. I'm just trying to put this in perspective. So he's up by the headlight, you crack your door open. Did you say anything or did you indicate you were going to say something, but then you said he told you to get out of the car?
I did say, hey, we're just dropping something off for Lisa.
Okay. Are you sure you got that set?
Yes.
Okay. So was that before or after he told you to get out of the car?
It was right when I opened the door.
Okay. So you open the door, you say something, but your door was just cracked.
Yes.
And you had 7 girls in your car.
Yes.
Okay. And then you say something, and then what happened? He told you to get out of the car?
Yes.
And so then you reached back in, put the car into park, you said?
Yes.
Okay, so when you reached back in, did you turn?
I just reached down.
Did you look down?
Yes.
So where was your hands at? So you have one, did you have a hand on the steering wheel?
Yeah. Yes.
Which hand on the steering wheel?
Left hand.
So your left hand's on the steering wheel. Did you open the door with your right hand then?
Left hand.
So when you
So I
opened,
let go of it and
Okay.
switched hands.
so you had your left hand on the steering wheel, you reached down to open the door. Where was your right hand?
When I opened the door,
Yes.
on the steering wheel.
Okay, so you had left hand on the steering wheel originally. When you reached over to open the door, you put your right hand on the steering wheel.
Yes.
So you open the door a little bit, you go to put the car in park, he tells you to get out of the car. So then you reach back up with your left hand and reach down to put it in park with your right hand?
Yes, I believe so.
Okay. So you reach back up with your left hand, grab the steering wheel, turn and look down by your right hand by the center console.
Yes.
Now is there an automatic or a standard?
Automatic.
Automatic. So you reach down, you turn, reach down. At that time, is that when he grabbed you?
When I sat back up.
Okay, so you reach down, you put it in park, you turn back towards him, right?
Yes.
What did you do with your right hand when you turned back towards him?
I
You don't remember?
don't know. Just, it was probably still on
Still on
the.
so you turn back towards him, your right hand's still on the shifter. Is that when you started to get out, or is that when he grabbed you?
I hadn't started getting out yet. I was just getting back to sitting up so I could get out.
Getting back to sitting up, had you been what do you mean sitting?
I just pushed put it in park.
Put it in park, as you turn back,
As I turned my head, yeah.
as you turn back, that's when he grabbed you?
Yes.
And he grabbed you by the hair?
Yes.
And at that time he grabbed you by the hair, was your right hand still over here by the center console?
I don't know.
But it could have been.
I guess.
Well, you said you're turning back like this, and that's when you get grabbed by the hair. So I'm assuming your hand's still here on the shifter at that time, isn't it?
Yeah.
Is that a fair assumption?
Yes.
Okay. And so he grabbed you by the hair and he says, get out of the car? Or I told you to get out of the car, is that the second
I
time?
said get out of the effing car.
And that was the second time he told you.
Yes.
And so as you get out, do you reach for anything? Where do your hands go?
Just braced myself on the handle on the door.
With which hand?
I don't know. My right, probably.
Okay, so you turn towards him and put your hand on that door, and then you stand up and get out.
Yeah.
And at this time, he had one hand in your hair, right?
He had
Over
let
your
go
head.
of my hair.
Excuse me?
He had let go of my hair.
He let go of your hair by that time. Okay. So when did he let go of your hair? When you turned to get out?
Yeah. Yes.
So you turn to get out, your hand's on the door handle, you're standing up, and he no longer has a hold of your hair.
Yes.
And so do you stand straight up?
Yes.
And so when you're standing up, you said he's in front of you?
Yes.
So is he on the other side of the door from you?
I was just standing next to the car and he was right by the back door.
Okay, so originally he was up here by the headlight in the front of the car when he told you to get out. So as you reached over to put it into park, at some time he had come from the front of the car then to the door.
Yes.
And when he reached in, he was behind then the doorpost that would be right here?
Yes.
So when he reached in, he was behind the doorpost and he reached in and grabbed you.
Yes.
Do you know whether he grabbed you with his right hand or his left hand?
I don't know.
Okay. Did you see a gun at that time?
When he had my hair,
Yes.
my head was pulled down so I didn't see.
Okay. And as you got up and stood up, you then turned towards him?
Yes.
Because he's back here by the doorpost.
Yes.
So you turn towards him, your door's open, right?
Yes.
You get up, you stand up, you turn towards him, and he no longer has a hold of you.
No.
Okay? And did you see the gun then?
Yes.
And how was the gun, how was he holding the gun?
Just 2 hands pointed at my head.
So he had 2 hands?
Yes.
Was it pointed down
No.
as you were getting out?
I don't know about when I was standing up. After I stood up, that's when it was.
With both hands on it?
Yes.
And it was pointed at your head?
Yes.
And where were your hands?
Down at my side.
Down at your side?
Yes.
Okay. How far away was he from you?
2 feet.
Okay, so we're this far apart, you were the same distance as me and him?
Yes. Maybe a little further. Not much though.
About this far maybe?
Yes.
So 3 or 4 feet?
Probably 3 feet. 2 to 3.
2 to 3, and he had his hands up and the gun pointed at your head?
Yes.
Okay?
Sir, if you'll give me your full name and spell your name for the record.
Scott Lewis Gay, SCOTTLOUISGAY.
If you'll get a little bit closer to the microphone, the recorder will be able to hear you better. What is your occupation?
I'm a police officer for the city of Blackfoot.
Mr. Lovell, you may inquire when you're ready.
Thank you, Your Honor. Morning, Chief. You said you're a police officer. What's your current assignment?
My current assignment, I'm chief of police for the city of Blackfoot.
And do you know the defendant, Mr. Rowland?
I do.
How do you know him?
Thinking probably late 80s, early 90s. He came here as a trooper. Then went to work for the county.
And were you on duty the morning of November 10th, 2021?
Yes, I was.
And did anything of consequence happen that morning?
Yes. Craig came into my office that morning to speak with me.
And by Craig, you mean the defendant, Mr. Rowland?
Yes,
Okay. Did you ask Mr. Rowland to come in?
I did not.
And when he came in, what happened?
He'd asked about the investigation from the night before, and I told him that it had been already turned over to the state police.
And after you told him to turn over, did Mr. Rowland say anything else?
He said they had really screwed up the night before, and that he didn't know what he was thinking, but he said that that night his dog was barking outside, a little Yorkie as I recall. He said he went out to see what the dog was barking at, saw 2 people running away and screaming, got his dog, went back inside. After he was inside for, I don't know how long, but he said that his Ring doorbell activated and they heard that his front door, screen door rattle.
Okay, so he's explained that his Ring doorbell activated, he heard the front door. What did he say happened next?
He told me he'd had a drink but was not drunk. He said that he went outside with his socks, long johns, t-shirt, and a gun with no flashlight. Said that he saw a car coming, I think he described it as his cul-de-sac. I think of it more of a dead-end road, but he said a car coming from the dead-end side of his road, coming towards his home, and he went into the street at that point to stop the car.
Okay, and you said that he was wearing socks, and what was that you said he was wearing?
Long johns and a t-shirt, if I,
Okay.
that's the way it is, when I recall.
Okay, so he said he got to the road. What did he say happened next?
He said he stopped the car by standing in the road, approached the driver's side. The door opened, or I kind of got confused on this part, whether the door popped open kind of thing, or he opened the door. But he reached in and grabbed the driver by the hair and pulled them out.
At any time during your conversation, did Mr. Rowland say anything about his, how he was thinking?
I know he told me that he felt like he wasn't in his right mind and that he didn't know what he was thinking.
No further questions, Your Honor.
Closing arguments, I'll hear from the state first.
Thank you, Your Honor. And is it okay if I remain seated for that?
You bet. Pull that microphone up close so they can hear you.
Of course. So I won't spend time on the standard because I know the court is well aware of the probable cause standard that applies here. There's 2 felony charges, the aggravated battery and the aggravated assault. I would like to spend a little bit of time on the aggravated battery. If you look at the standard jury instruction for aggravated battery, one of the elements is that in the commission of a battery, the defendant used a firearm or deadly weapon. And if you look in the comments to that standard jury instruction, it says, use of a deadly weapon to intimidate the victim to endure physical contact, which he otherwise would have resisted or attempted to evade, fits the definition of use of a deadly weapon. And then it cites to a Court of Appeals decision, State v. Cates. That's a 117 Idaho 90. And the Cates decision took a very broad interpretation of the word use as it applies there. And what happened in Cates is that according to the victim's testimony, the defendant briefly, is the word the Court of Appeals used, briefly displayed a firearm to her before slapping her in the face. And on appeal, the defendant argued, well, that's not enough because he didn't actually use the firearm to make contact with the victim. And the Court of Appeals rejected that argument and said there was a factual nexus between the firearm and the contact of slapping in the face, and that is sufficient to satisfy an aggravated battery charge. And so in this case, the way that would apply is, as we've heard from the testimony, the defendant pointed his gun at Ms. Cox and then pulled her hair. That would be the battery, the pulling of the hair. That's the force or violence or touching without permission. And the gun had a close factual nexus to that. It was displayed. There's been no evidence shown that he did not have a gun that night. The third ring video that we played, in fact, showed him holding that gun. And so that use of the firearm is, in fact, satisfied for the aggravated battery. On the aggravated assault, the court heard the evidence when Ms. Cox got out of the vehicle, and the assault is charged as when after she's out of the vehicle. The defendant pointed a gun approximately somewhere between 2 and 6 inches from her head and told her, "I'll fucking shoot you." That is textbook aggravated assault. Ms. Cox commented on how that made her afraid. I would point the court to her testimony about driving off. She said he tried to close the door. It couldn't close because my foot was in the door. He tried again to close the door. It didn't close because my foot was in the door. And I started driving before the door was closed. Clearly this court is able to draw reasonable inferences from the evidence based on Ms. Cox's testimony, and that evidence that has been presented. This court can find or infer that there was a well-founded fear in Ms. Cox, that the violence the defendant was threatening was indeed imminent. And so that satisfies the aggravated assault. Now, just briefly, I want to touch on some comments that the questioning from defense counsel and some of the statements that have been made suggest that defense counsel is going to be asserting some kind of affirmative defense in this case. The state's position on that is twofold. Number one, Rule 5.1 does not mention affirmative defenses. The state takes the position that it does not have the burden to prove probable cause or any other standard that an affirmative defense does not apply at the probable cause hearing. Instead, what Rule 5.1 says is that it requires substantial evidence on each element of the crime. And we've done that. So that's kind of our initial position. But regardless of how the court decides that, the court doesn't really need to decide that because the evidence presented in this case shows, at least to a probable cause standard, that there is no affirmative defense that would apply here. Specifically, Mr. Olson has mentioned that as the sheriff, he is somehow immune to these kind of activities or to these charges in a situation like this. Idaho does not have any kind of freestanding immunity to law enforcement officers. That is not a thing. There is a specific statute that delineates when a peace officer is immune from charges of assault and battery. And that is found at Idaho Code 18921. And it states, no peace officer may be held criminally or civilly liable for actions or omissions in the performance of the duties of his office under this chapter if the peace officer acts in good faith and without malice. So you have to be a police officer, and then there's 3 additional requirements. You have to be performing the duties of your office, and you have to do it in good faith and without malice. Here, the defendant doesn't check any of those boxes. There has been no evidence presented that would suggest in any way that there was some kind of criminal activity that needed to be investigated. We asked several of the witnesses if they had seen any no trespassing signs. They had not. The trespass statute is the only statute I'm aware of, criminal statute, that specifically delineates examples of what is not a trespass. And it specifically says in there that it is not a trespass to knock on someone's front door if not a property that's not posted with no trespassing signs. So what they were doing was not a trespass. There's no other indication that there was any kind of criminal activity that was going on. So he couldn't have been investigating law enforcement or otherwise. So he couldn't have been performing his duties. On top of that, he was not acting in good faith. So even if we assume for a second that he was performing some law enforcement duty, he would of course be governed by the Fourth Amendment, and he would need something like probable cause or reasonable suspicion to stop a vehicle. Once he saw that turkey, and the second ring video clearly shows that not only did he see it, but he read it, said the words, "Thank you, that's bullshit, get my gun." Any hint of suspicion from someone knocking on his front door was dissipated entirely when he saw that paper turkey. And for him to then arm himself with a weapon, which he didn't have until he saw the turkey, go out, flag down a car, point his gun at the car, and pull the driver out by her hair is simply not good faith. That's not acting as a law enforcement officer within even seeing distance of the Fourth Amendment. In addition to that, Ms. Cox indicated that the defendant did not at any time identify himself as law enforcement. So the defendant can't have it both ways. There's really 2 options here. Either you recognize that it was Ms. Cox, in which case his aggression was completely unwarranted, or he didn't recognize that it was Ms. Cox and therefore could not have inferred that they already knew he was a police officer. And for a police officer to put a woman and 7 minor children through something like this without ever identifying himself as a police officer is bad faith. And then finally, the without malice box. The Idaho Code defines malice as to vex or any intentional wrongful act. And vex, of course, means to annoy, to cause anxiety to. These acts were all intentional. There's no evidence whatsoever they were not intentional. And there was nothing that happened that night that was right. This was all wrongful conduct. So that the immunity just doesn't apply. And then briefly, Your Honor, the only other self-defense the state can even dream of, or the only other affirmative defense the state can dream of is self-defense. And of course, in Idaho, that would require that there be a threat of imminent harm and that the defendant's response be reasonable to that threat. Again, no evidence of any kind of threat whatsoever. The defendant's actions were not reasonable. And then, of course, under Idaho law, you cannot claim self-defense if you are the initial aggressor. The defendant here was not only the initial aggressor, he was the only aggressor. There is nothing that happened that night that could reasonably be interpreted as a threat to the sheriff, to his property, or to anyone around him. And so the state believes that it has not only proven the elements of the crime, but it has also shown that no affirmative defenses apply. And then just briefly, Mr. Olson did bring up an issue about jurisdiction earlier on. I would just point out the affidavit that he was reading from was referring to a very specific statute, a public corruption statute, and that is what gives the Attorney General's office jurisdiction to investigate certain cases. And one of the requirements that has to be met for us to investigate is that the elected official was acting in his official capacity. But that statute has a very specific definition for acting in your official capacity. And it includes, if you are using public property of any kind, then no matter what you are doing, you are deemed to be acting in your official capacity. And so the fact that he was using his county firearm means he was acting in his official capacity, which gives us jurisdiction, but that does not in any way imply that he was properly fulfilling the responsibilities as sheriff. And then I would just also note that even if that were an issue, we would still have jurisdiction because at the very beginning of this case, the Bingham County prosecutor conflicted the case to us. And so we have not only a belt, but suspenders when it comes to jurisdiction here. And so for all those reasons, Your Honor, we'd ask that the defendant be bound over to the district court.
Thank you, Mr. Knight. Mr. Olson.
First of all, Your Honor, we'll talk about the jurisdictional issue. I think it's interesting that the Attorney General wants to keep saying it's a public corruption statute. That has nowhere in the code. They want to inflame the public. They want to use all these big, broad, inflammatory terms which have no basis in the law. Article 31, 2002 allows investigations and actions against county elected officials to the Attorney General. They may investigate that as long as that county official is acting in his official capacity when such act takes place while the officer is working or claims to be working while the officer is at his workplace, whether or not he's working at the time, and involves the use of public property or equipment of any kind or the expenditure of public funds. It's not a public corruption statute. It's a jurisdictional ability for the Attorney General to investigate crimes, general crimes. So, just want to clarify that inflammatory term they keep wanting to use. As to any assignment from the county, I have not been provided a copy of any assignment. I don't know if the court has one, but I have not seen anything. So his belt and suspenders, I think, are not there. So the Attorney General today has not put on any evidence. I tried to ask those questions as to whether or not Sheriff Rowland was acting in his official capacity at the time of the events. They objected. The court sustained that objection. So if they don't get that, they don't have any jurisdictional authority. None. They have to have jurisdiction, otherwise they're improperly here. So that's the first issue on which the Attorney General has failed to comply with. The second issue is they keep saying that he's not working. So on one hand, they want to say he's acting in his official capacity, so they have jurisdiction, but on the other hand, they say, well, he can't be while he's at home. Well, 31-2202, the duties of a sheriff is mandatory. He shall perform the following functions: breach of the peace, preserve the peace, take persons before the magistrate who have committed a public defense, etc. He is on duty 24/7 as the elected sheriff. He doesn't get to go home. He doesn't get to check out. He doesn't get to say, oh, there's a crime committed at my house, and call law enforcement and say, I need the sheriff to come respond to me. He's the sheriff. He's on call all the time, whether he's in his pajamas trying to go to bed or not. Council also apparently has not read the modifications to the trespassing statute that our legislature did in 2018. Acts constituting trespass. If you enter or remain on real property of another, in addition, a person has reason to know that his presence is not permitted on real property that meets any of the following descriptions. First one, I. The property is reasonably associated with a residence or place of business. 2 is cultivated. 3 is fenced with no trespassing signs. 4 is unfenced and uncultivated but posted with no trespassing. Number 1 is a residence. You are trespassing if you go to somebody's residence and you have not got permission. That's what our legislature's passed. Whether you like it or not, you are not allowed to go to somebody's residence unless you have permission. Did they request permission that night to go to the residence? No. They first went there, and whether they want to say they were ran off, whether they were scared off, whatever, they took off. They came back when the lights were off. When they first went there, the lights are on. And you can see in the one video, when the lights are off, how dark it is. It's the end of Exhibit 4. It is black. Exhibit 3, when you see the juveniles come to the home, and you can see them, that's because of the infrared in the camera. The court can still see that it's black. They're sneaking in, banging on doors, and running away so they don't get caught. If that's not trespassing, I don't know what is. If that's not disturbing the peace, I don't know what is. So what does he have an obligation to do? He's got an obligation, not just a right as a citizen of our great state, to go see who's banging on your doors, who's opening your doors. You can see they opened his door and then do something to his front door. Now the sound's missing in that video, but they clearly showed they're opening that door in that third exhibit. Ring the doorbell, bang on the door, whatever they do, but they entered the doorway, they opened the door. They don't put it on the outside, they put it on the inside. When you open that door and enter that, you've committed an unlawful entry. That's a crime. So as a citizen, you have the right to go out and see who is attempting to enter your house, who is trespassing on your property. He has an obligation as the sheriff to ensure that somebody isn't casing out the neighborhood. Some strange car that's beat up is trying to get away. Got away one time, as you can see in the first video, Exhibit 2. He goes out and he watches as the car was leaving, according to Miss Cox. She never looked back, but they took off out of there. You don't see him come back in. We're missing that video. You don't see what else he's doing. After the girls take off the second time, you don't see him go out after him. Where's that video? You see him come back. He goes out to the road, stops the car. It's an unknown car, didn't recognize it. Lights are on, as Ms. Cox testified, facing him. She knows he's the sheriff. He never has to identify himself as law enforcement. I don't know where the AG's is getting that idea that somehow you have to identify yourself as law enforcement in order to be under the cloak of immunity of law enforcement. It doesn't happen all the time. It may be good process, good procedure, but it's not required. We're seeing how many cases where people are arrested by undercover agents. How many times are people chased down by somebody that's undercover, not wearing uniform, not known to the people, and they run? And they get charged with eluding, resisting and obstructing. If that's the standard the Attorney General wants to have, then they need to start charging law enforcement across the state. He stops the car, checks to see who it is. The person opens their door. Again, we got a beat up car in a private neighborhood that is not recognized. He, as the sheriff, has an obligation and a duty to protect his neighborhood and his county. This is dark. This is nighttime. This isn't during the day. He has an obligation to do that. Stops him. This person gets out. And not only does this person not just get out, Your Honor, what's even worse is this person reaches over, opens the door. When he says get out of the car, they reach to the center. What is that? That's a safety issue. What's that person reaching for? Is there a gun? Is there a weapon? What are they reaching for? They're not getting out. Just so happened she was reaching to put the car in to park. He didn't know that. It's dark, unknown person, unknown car in a private neighborhood. So he's just banging on his door, trespassing. Second time that night. Says, get out of the car. AG wants to use, well, he said the F word and effing and fucking or whatever. They're inflamed. They're just trying to inflame the media. They're trying to inflame the public. But that has nothing to do, the words he used have nothing to do whether or not a crime was committed. He tells you to get out of the car. She reaches for something. He grabs her by the hair. She then gets out. As she testified, he let go of her hair. Had the gun pointed at her. Where are her hands? What do you watch for as law enforcement? Number one, you watch for hands. Why? Because there's weapons there. Why? Because that's what you're trained to do. Because why? If you don't, you get killed. Where's her hands? They're not up, they're down. What are we supposed to do when we got a gun to our face? You put your hands up. I don't have a weapon. Why do you shake with your right hand to show that the person you're shaking hands with does not have a weapon in their hand? It goes back centuries. Her hands are down at her side. He's got the gun pointed at her. Who are you? What are you doing here? Who are you? Doesn't recognize her. She says, Chelsea. He says, who? Or yes. And apparently recognizes her and tells her, get out of here. I could have shot you. Get out of here. Or maybe he said, I could shoot you, or I could have shot you when she's got her hands to her side. You got law enforcement. You know he's a sheriff. You know he's a cop. Career law enforcement. You come out of a car with your hands down. You got a gun to you, and he says, what are you doing? Who are you? Chelsea. Chelsea, yes. Get out of here. At that time, he has made the determination that he doesn't feel there's a threat to him, to his safety, criminal activity going on around his neighborhood. He tells her to leave. That scenario, if that was videoed on an in-car camera, you've seen dozens of them, Judge. The only difference is you got a car behind you with lights. But you see the exact same scenario. People reach for the center console, law enforcement will pull their gun. Where is he standing at? Exactly where he's trained to do, on the back post. Right here behind the driver. Why? Because then they have to turn to attack you. She reaches, he grabs. Get out, she gets out, he backs off. Making sure he's safe. There's no evidence that he knew anybody else was in the car at the time. What does she say? She's scared. She says, he didn't recognize me. She never said, I thought he was going to shoot me. She never said, I was scared for my life that I was going to be shot. She says, I was worried he didn't recognize me. A person that's cared for, been a neighbor her whole life, grew up as like a daughter. Didn't recognize her in a beat-up car. Late at night. Well, 8 o'clock late at night, where there was time change going on, but that's a matter of perspective. It's clearly dark. So when we get to the statute, is there any evidence he intentionally and unlawfully touched her? The state, the AG, has not put on any evidence this was unlawful. They have to prove it's unlawful. That's one of the elements they have to prove. They have to put on evidence that it's unlawful. What evidence is this unlawful? Investigating potential criminal activity. Checking out who is in our private neighborhood as the sheriff. That's not unlawful to do that. It's not unlawful to point a gun at somebody. If it is, you better start charging law enforcement across our state. The AG is going to be very, very busy. But they don't charge these. Who do they charge? They charge Sheriff Rowland. Not only do they charge him with an assault, but then they want to charge him with an aggravated battery because he touched her when she's getting out of the car, somehow alleging that that makes it an aggravated battery because he also had a gun. And they want to use that odd case of Kate, Your Honor, out of Bannock County, where a woman was bound, gagged, raped, and a firearm was used in the commission of those crimes, and the jury didn't find that person guilty of the crimes they were charged, but a lesser included of aggravated battery. And there was evidence that she may have been touched with a gun. I mean, that's a weird case. Frankly, I think the Supreme Court tried to justify the conviction, is what they did, because he didn't get convicted of the rape and the kidnapping and everything else. So that's a weird case. But the gun never touched her. She wasn't hit with the gun. She wasn't beaten with the gun. If the AG's position is if you have a gun and you touch somebody and that becomes an aggravated battery, then there is no basis for an aggravated assault. I mean, that merges into the aggravated battery. But there's no aggravated battery. Again, no evidence of the fear. There's no violence. There's no malice. Law enforcement is immune. AG's hasn't put on any evidence of malice, nothing. Frankly, if the sheriff wanted to, he could have charged Chelsea Cox. He could have charged these girls. These girls could still be charged with crimes. He hasn't done that. They could be. They committed crimes. The AG's office, number one, hasn't put on any evidence of their jurisdictional ability to even prosecute this case. They haven't put on sufficient evidence under count 1 and count 2. Count 2 specifically the well-founded fear, which makes the assault. And the battery, this is not an aggravated battery because he grabbed her by the hair because she was reaching for her center console. I remember getting stopped by law enforcement for speeding one time, and I reached for my center console, and I had a 45 stuck in my ear so hard, I about pissed myself. And I got told, boy, you better reach real slow. Just because I reached for the center. Because that's what law enforcement is trained to do, is to protect themselves. You don't do that. He was absolutely within his rights as law enforcement, within his duties and obligations, and we would ask the court to dismiss these counts.
Thank you, Mr. Olson. Any response from the state?
Just very briefly, Your Honor. Under the Trespass Statute, if you look at subsections 6 and 7, it spells out that knocking on someone's front door is not a trespass. The defense's interpretation of the law that going to anyone's house without an invitation is a trespass, just so everyone's aware, that is not correct. You can go to people's houses without an invitation and not be trespassing. Unless the court has any specific questions about anything else, we're fine.
The court has listened carefully to the evidence. The court has looked at the exhibits. The court does find the state has met their burden as to each and all elements of count 1 and count 2 charged as felonies. For the preliminary hearing as to a probable cause standard, the defendant will be bound over to the district court. As far as dates for the arraignment to take place, it looks like March 17th at 1:30 p.m. is what the court clerks would prefer. Any objection to that date and time, Mr. Nye or Mr. Olson?
No objection from the state, Your Honor.
Your Honor, I believe I'm scheduled to be in a trial in your neck of the woods on the 16th, 17th, and 18th.
Okay.
So,
All right. What we'll do, it's going to take a little bit of logistical planning to get this scheduled if that date didn't work. So what I'm going to just ask the attorneys to do is get in touch with the clerk, let them know your available and unavailable dates. We'll set this for an arraignment. It's likely going to be in front of Judge Dunn, and we'll work with his calendar as well and get that scheduled as soon as possible. Any questions, Mr. Nye?
No, Your Honor.
Mr. Olson?
no, Your Honor.
We'll be adjourned.